suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
We are dispensing that free legal advice right now with David Whiting, your real good lawyer, who's here in the studio with me. He didn't take a leave of absence. He just absented himself and did it down the line last week because, of course, there was a COVID test in the office. How did we go?
We passed.
We passed.
So the person who
Flying
had the
colours.
COVID test passed.
Yep.
But I just felt it was, if we follow all of the advices, we did the right thing.
No, it's absolutely the right thing to do. Before we get into talkback, I am interested in your view because as a lawyer, I know you don't pay close attention to everything, but it would have been impossible to avoid, of course, the legal discussions around the allegations that have been made against the first law officer of the land, the Attorney General, and other issues besides. Have you turned your attention as to whether there can be some sort of, from a legal point of view, because we're being told, the rule of law applies, and if the police haven't investigated this, then there's nothing more to see here, and we don't have a particular individual inquiry into the Attorney General himself or whether he's a fit and proper person to hold that position. What's your view?
Look, I had lots of ums and ahs trying to work out what, in fact, an inquiry would be designed to establish. Because it struck me that if we're trying to determine whether Christian Porter is guilty or not guilty of a particular offence, it's the unwinnable argument because you would never be able to. The evidence is not capable of being fully tested. We're talking about an event that happened a long time ago, not that that makes any difference. But at the end of the day, there could never be a conviction on the basis of whatever evidence was available.
And that's been made clear, yeah.
So if we're trying to try him for the offence, then I come along and say no. If there's to be an inquiry, and I don't object to the inquiry, there was an article in Today's Age that basically says what you could have an inquiry to determine, because suitability to be a government minister,
a fit and proper
person is different from whether or not you have or have not committed a criminal act.
Yeah, and you don't litigate that matter as part of your fit and proper person test.
No, but you look and see, I can't see that getting up because if you look at the way the two major parties choose their ministers, I look and see that in the Labor Party, the Premier or the Prime Minister is told who the members of the Cabinet will be and the Prime Minister has the ability to apportion portfolios. And in a Liberal National Party government, it's the Prime Minister who determines who gets the chair.
Yep.
So, and I actually see that a lot of those are determined by factional issues, not always the best person for the job.
That's very true. So the inquiry that was put in place following High Court revelations about sexual harassment by a former High Court judge, that wouldn't apply? That couldn't be used as a template?
Well, they had the advantage that he wasn't there anymore, that made the court's analysis better.
That's very true. It's a good point. There wasn't then any uncomfortable consequence for the court receiving the report and going, oh, what do we do now? We've got a sitting High Court judge.
But I must say I'm remarkably cynical about politicians.
Are you?
Well, aren't we all? Should we not all be cynical about politicians?
Sceptical. I prefer sceptical.
Sceptical. Okay, all right. Sceptical, very sceptical. And I come along and because it's a reflection on my choice. If I'm required to determine whether someone I have appointed is a fit and proper person, then that reflects on me. I wouldn't want that to happen.
No, absolutely not.
No.
All right, well, this one's yet to play out fully, but in the meantime, we can offer some advice.
We can.
1300 222 774, but you've got some homework, haven't you?
Yeah, Derek lived in Croydon, and Derek owns a property that a public hospital has earmarked for expansion.
Oh, yes, that's right, yeah. But they haven't actually said, give me the property and here's the money.
Yes. So they haven't done that.
And he wants the money.
Well, he wants to do something about it. He wants to force the issue. Yes, but if you think about the east side of Punt Road between the bridge and St Kilda Junction.
Which I don't often do, but okay.
No, it has a road widening reservation on it that's been in place for 70 years.
Right.
And yes. So
they just live with the sword of Damocles hanging above their head.
Well, let's break it in. If you are affected by a planning instrument with a public acquisition overlay on it, and the overlay comes into existence when you own the property. You're able to make an application for compensation. Now, the compensation that you get will be for the drop in value of your property. So if you own a property worth $1 million and it's now worth 800 because of the acquisition and the uncertainty about everything else, then here's a cheque for $200,000.
So what can he do?
He can make an application under Section 98 of the Planning and Environment Act, and he claims compensation for the Planning Authority for financial loss suffered as the natural, direct and reasonable consequence of the allocation.
Okay.
So
does he need a lawyer for that?
Does he get the property? Well, he certainly needs a planner, and he needs a valuer who's approved.
All right, let's go to Claire in Greensborough, who's first up this morning for Legal Talkback. Hi, Claire.
Good morning. It's a bit of a conundrum, but 20-odd years ago, about 18 years ago, we moved my parents from the western side of town across to this side of town. We had to make up the shortfall with a mortgage, so my husband took that on. When my father passed away, unbeknownst to us, it was quite a traumatic experience. His name was never taken from the title. Now, my mum has had a fall and has been diagnosed with being quite unwell, and we're looking at care. And we've plucked the title out to work out what we're going to do as far as mum's, RAD for her care, and discovered that Dad's still on the title. We don't know what to do from here.
Piece of cake, Claire. Do you have a power of attorney for your mum?
I do.
Then you can prepare, and is the mortgage gone off the title?
Not yet, no.
All right, but it will as part of this process. You can lodge something called an application by surviving proprietor, and you can give the appropriate instructions on your mum's behalf, and it's basically an application that she makes but you sign that says that the husband died on this particular day and she's entitled to be registered as the sole proprietor. That will require the bank's assistance because they need to make the title available for an endorsement that shows that your mum is now the sole proprietor, but a very, very, very straightforward process.
Thank you so much.
There you go. Well, that's a nice, easy one to solve. Terrific to hear that. Corinne is in Castlemaine. What's going on, Corinne?
I just wondered what the legalities are of retail establishments refusing to accept cash.
It depends upon when the refusal occurs. There is a piece of legislation that says that cash is a good discharge for all debts, public or private. But the debt has to arise first. So if you were to walk into a supermarket and fill your basket and take it to the checkout and you were to put everything out, what the law says is that you haven't bought any of that stuff yet. You've in fact just offered to purchase it. So at that point there is no debt because there's no sale. And if they tell you that we're not going to take cash, then they don't have to take cash. Mind you, I've always found it interesting that the Commonwealth Government's main receiver of money, the Australian Taxation Office, won't take cash.
Yes, it is strange. You can't just go there with a sack of cash. So what you're saying in essence is that it's their right.
It is their right to refuse to take cash.
So sorry about that.
Because the
Corinne's
debt
probably a cash
hasn't
person.
arisen. Yep.
All right, say that again.
The debt hasn't arisen. There's no at that stage.
Yep. So
if you go in and you buy a car and all the paperwork gets signed and you take out your $50,000 in $10 notes, well, I'm sorry, they don't really have a choice.
Okay. Frank in Woodside, hello.
Yeah, hello. I've got a small property in Gippsland, Woodside, and purchased it 15 years ago. There's an easement running between the two properties for future sewage works, potential sewage works. The neighbour next door removed the fence some time ago. He sold the property, and we spoke to the new owner, and he has since sold the property as well. They're just concerned about adverse possession because now the fence has been down for some time.
An easement isn't property ownership. It's an ownership interest in land, but not, if you like, of the land. So if there's an easement, then the easement is on someone else's property. So there might be an easement over your land in favour of, say, the council or the water authority. So the easement would stay, but if there was adverse possession, it would need to be 15 years. And I'm fairly sure I know you can't get adverse possession against the Crown, and I don't see that you would be able to get adverse possession against an instrumentality. So if it's a council or the water authority, it will simply stay there. But you need to work out whether the easement's on your property or your neighbour's property so that you can be satisfied because let's assume that the easement is on your property, but the fence is on the other side on your side of the easement, then your neighbour could get adverse possession of the land above the easement while leaving the easement in place. Does it make sense? Your property could get smaller and your neighbour's property could get bigger.
Right.
Yeah, that's what we're concerned about. Yeah.
Well,
okay.
then,
so
but then work
should we
out.
notify the council? Or
No. Your issue is whose if the easement is on my property, is it inside my fence?
Yep.
Okay.
Yep. How do we find out whose property is?
Well, have a look at your title.
Yep.
And you can do a title search at a land registry search, about $20.
Might you need a surveyor as well?
Well, no, the first thing he wants to know is whether there's an easement shown on his title.
Yep.
That's a process that's going to cost him $20.
Yeah. I've got the subdivision from when we purchased the property, all right?
Yes.
And that just shows an easement, marked easement for, I think it says for future sewage.
Well, it'll say easement for sewage. It'll say the easement's marked E1, E2 or E3.
Yep.
If there's an easement, then the chances are the easement's on your land.
Okay.
All right? So it
Good
sounds
luck.
like the fence is on the wrong side.
And it sounds like we need to have a look at the titles in order to clarify that. Michael's called in from Maryborough. What's going on, Michael?
Oh, g'day, Virginia and David. I have the licence to a government road that runs between properties that I own on both sides for the top half of it, and on the bottom half I own a property to the west and a neighbour owns a property to the east. The previous owner of that property to the east built an ostrich farm, and he built the fence line right down the middle of the government road. He's since well and truly moved on, and I'm wanting to repurpose that fencing elsewhere. As a licence holder to the government road, do I have the authority to go in and remove that fencing from the government road? I'd obviously discuss this with the new neighbour first. He doesn't live there. He only has
Michael, the expectation is that the line that is fenced is between your neighbour's property, the man without the licence, and the unused road. You can incorporate the unused road as part of your property if you want to.
Yep.
So it's possible to move the fence. If you were going to pick it up and move it to somewhere else, that makes me a little bit cautious about who might own it. In Victoria, we tend not to ask who owns fences, but in other states they do ask. So you could certainly move it to the line. You could move it to your boundary with the neighbour,
Right.
if you wanted to.
Right. Because it's not a boundary fence. If I was to go in there and start removing it and he were to turn up, it would appear to him as though I was in his paddock pulling down fencing.
Well, then you would be putting an awful lot of effort to make sure he's satisfied it's going in the right place.
Yes.
How big is the unused road?
It probably is about 500 metres long, and it's about 22 yards in the old language, so just over 20 metres wide. Yeah.
Okay.
So
I would be, I would certainly get your neighbour satisfied that you're moving the fence to the right place.
All right. That's the best thing to do. Good luck with that one. Now, Joseph's called in from Fitzroy with an intriguing dilemma. Hi, Joseph.
Hi, how are you?
Good, thanks.
Thank you for giving me a chance to talk to you.
Yep.
And thank you, David, for this.
Thank you.
My name is used in an email, which is not my email, and that email is circulated among a few of the people whom I know. Now, the email address is not mine, but the name is mine.
Yes.
It's called impersonation. And what law in this country is to protect me for that?
There are two aspects, Joseph. There's a criminal aspect and a civil aspect. But there's no law that prevents you from adopting another name unless it's for an improper purpose. So if someone was I don't know, as a joke using your name. But so if someone was to, I don't know, attempt to obtain money using your name, that's a criminal matter that you could take to the police. But if someone was simply making fun of you, if you like, that may or may not be a criminal consequence. So there's no, you would have an action to restrain someone damaging your reputation. And every now and then you will see cases brought against Google or Facebook trying to identify a person who is using that is posting things on a website pretending to be someone else.
Joseph, are they using your name, or are they using your name and pretending to be you?
Pretending to be me, but because there is no other name in my friend's circle. There's no other person.
And what are they doing with these emails? Are they trying to get money or doing anything, or?
No, they're making first thing defamation against me, like putting my improper comments, which I never do things.
Okay.
Yeah.
So they're misrepresenting themselves as him.
Yes. To me, the biggest problem is how much is this going to cost to fix? I mean, perhaps the answer might be that you email all your friends and you tell them and ask them to block that email address.
Joseph, could you do that?
I can do that, but the respect for my person. Some people believe me that I don't do it, and some people are just think that I have done it.
They've believed you.
Then you have an action against the person who did it, but you have to find them. And that's
you
not
have to go
going
to
to
the
be
police,
easy.
don't you, as well?
But what's the crime?
That's the question.
Yes.
So there is none.
Well, there may not be one. You actually need to analyse if there is a crime. And if there is a crime, then it's a matter that if you think there's a crime...
who can establish whether what's going on here is a crime or not, David?
If I was to write you an email pretending to be John Smith, does that mean that there's a crime being committed?
No, but that's what I mean. Who is the person in this scenario? You, the police, another lawyer to establish
I would
whether...
be taking copies of the emails along
to
the police.
To the police.
To see whether there is sufficient evidence of a improper purpose.
That's what we need to establish, whether there is. And then you can establish, Joseph, as you started your question, whether there are any laws in place that can actually protect you. Hope that's helpful. Ian in Cape Patterson, good morning. No, Ian's actually just dropped off, sorry. So Chris in Montmorency. Oh, okay. Ian's moved. Ian's now just there. Hi, Ian, what's happening?
Yes, I just wanted to make a small inquiry. My daughter is in a relationship with, has been for many years with her husband. Recently, they started off with the unit, which they bought, and then they progressed onto a family home. They kept the unit for quite a while and still have it, but it was recently transferred into the husband's name only. And they've now recently transferred their mortgage into another account, which I'm not sure who's that with. Didn't inquire too much. But if the partner signs over the family home or an asset to the husband only, does she forfeit that asset if the relationship were to break down?
No, she doesn't. It's still going to be a matrimonial asset. It's an asset of the relationship.
Okay.
So that doesn't change. And the reason why you might do it is to meet a bank's lending requirements. There could be different asset protection. There are lots of reasons why you might do it, but it's still an asset of the relationship.
Okay. That's
Good luck.
very helpful.
That's helpful.
Thank you.
Thank you.
Thank you very much. Bye.
Chris is in Montmorency. Chris, good morning.
Good morning. Thanks for your time. In 2014, my wife and I bought a property, and recently in December last year we decided to sell it. We went to get the documents raised to sell the property and subsequently found that the title was still in the previous owner's name. The conveyancer who was supposed to have done the work has since been deregistered. So we're now going through the process of getting the title changed to our name.
Yes.
To sell the property properly. Now, we already had a buyer before we knew we didn't have the title in our name. They have put a deposit down. This has been since the start of this year. I suppose two questions. Firstly, have you had any experience of this in terms of how long it will take to get resolved? And the other
with cooperation from the person you bought from?
Apparently so. The last thing I spoke to the solicitor about this morning was where it is, and apparently they're waiting for that person's bank to confirm that the mortgage was discharged at the time.
There's a document called a register search statement, but basically what we call a title search, and it will tell you whether the mortgage is in place or not. Now, in 2014, we did physical settlements.
Yeah.
If I was acting for you, I would turn up at settlement and we'd hand over some cheques, and I would be given a title, a mortgage, and a transfer of land. All right. Now, and that's a fairly simple process. And then I would go away and register those documents at the Land Titles Office. Now it's all electronic, so it all happens. But this is back in 2014.
Yeah.
So, but the bank will know very, very easily whether or not there is a mortgage in place. Yep. I would have thought you should be able to do it in 6 to 8 weeks.
Okay.
If everybody cooperates. But I've had a fantastic issue in the last couple of weeks about a Bank of Melbourne mortgage.
Yep.
Because if you recall, 20 years ago, Westpac bought Bank of Melbourne.
Yep.
And so I'm trying to get a discharge for a 1999. In 1999, my client had a Bank of Melbourne mortgage, went and got a discharge, but back then they weren't lodged. So he just kept at home his title and his discharge of the of the Bank of Melbourne mortgage, and then ultimately threw out the Bank of Melbourne mortgage because it was a worthless piece of paper in his view.
Right.
So we're now negotiating with Westpac, trying to say, you may have new computer systems, but So the register search statement shows that there's still a mortgage on the title.
Still a mortgage on the title. Wow.
Well,
Okay.
where we got caught was that
Just, I'll wrap you up unless you've got anything more you need to ask about this particular challenge.
I was just going to say we were told it was already electronic. That's why we didn't.
It is an electronic title, but it'll be electronic title shown as being in the name of the bank, because in about 2016, all titles in Victoria held by the major banks were converted to electronic titles.
Okay. Got just a quick last call here from Sandra in Mornington. Sandra, we've got just enough time for your question. I'm sorry. Go ahead.
I'll be very quick. Thank you, boss. This is to do with an AGM. I'm living in a retirement village. We have an AGM, and after the AGM, we have voting for the people that are going on the Committee of Management. We had a few issues about the actual voting, and I've requested to scrutinise those votings, the actual paperwork. I've been told I can't do that, but I thought under the Retirement Villages Act 1986, Section 18B allows all residents to look at any paperwork held by the management.
I'm going to take that one on notice. You'll just have to wait till next week, Sandra, because I didn't bring my copy of the Retirement Villages Act with me.
Okay, can I just say one quick thing?
Yeah.
The boards have no names on them. They only have the names of the people the nominees. And they're telling me I can't look at them. I can't even see if they've got my vote there because it's a privacy issue. I don't think it's a privacy issue.
No, I don't see it as a privacy issue either.
All right. Well, we'll try and establish that for you next week. That means
Thank you so
you have
much,
to listen
David,
next week,
and
Sandra.
I certainly will.
Thank you. Great to see you, David. Thanks so much. And David Whiting will be back with you at the same time next Tuesday.